The sitting is open. For reasons made known to me, Judges Tomka, Bandari, and Brandt, who duly participated in the deliberations and the final vote in this case, are unable to sit with us today. The Court meets today pursuant to Article 58 of its statute and Article 94 of its rules to read out in open court its judgment on the preliminary objections raised by Azerbaijan in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. Shortly after the completion of the reading of that decision, a second sitting will be held for the purposes of the reading of the Court's judgment on the preliminary objections raised by Armenia in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. I recall that the proceedings in the present case were instituted on September 16, 2021 by Armenia against Azerbaijan concerning alleged violations of the International Convention on the Elimination of All Forms of Racial Discrimination of December 21, 1965. I shall refer to that convention as CERD or the convention. Before delivering the Court's judgment in this case and subsequently in the Azerbaijan versus Armenia case, I shall briefly summarize the general background common to both cases. Armenia and Azerbaijan, both of which were republics of the former Union of the Soviet Socialist Republics, referred to as the Soviet Union, declared independence on September 21, 1991, and October 18, 1991, respectively. The region which Armenia calls Nagorno-Karabakh and Azerbaijan calls Karabakh was in the Soviet Union an autonomous entity or oblast with a majority of Armenian ethnic population, lying within the territory of the Azerbaijan Soviet Socialist Republic. The parties' competing claims over that region resulted in hostilities to which Armenia refers as the First Nagorno-Karabakh War and Azerbaijan refers to as the First Karabakh War that ended with a ceasefire in May 1994. Further hostilities erupted in September 2020 in what Armenia calls the Second Nagorno-Karabakh War and Azerbaijan calls the Second Karabakh War. On November 9, 2020, the President of the Republic of Azerbaijan, the Prime Minister of the Republic of Armenia, and the President of the Russian Federation signed a statement referred to by the parties as the Trilateral Statement. Under the terms of this statement, as of November 10, 2020, and I quote, a complete ceasefire and termination of all hostilities in the area of the Nagorno-Karabakh conflict was declared, end of quote. However, the situation between the parties remained unstable and hostilities again erupted in September 2022 and again in September 2023. I now turn to the judgment on the preliminary objections in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. In accordance with the usual practice, I shall not read out the introductory paragraphs of the judgment, which set out the main elements in the procedural history of the case. I shall also omit some paragraphs and summarize others. I shall therefore begin reading the judgment at paragraph 34. The full text of the judgment will, of course, be available at the close of the sitting. In its application, Armenia alleges that Azerbaijan has breached several provisions of CERD by virtue of a decades-long state policy of racial discrimination. Specifically, Armenia asserts that, and I quote, as a result of this state-sponsored policy of Armenian hatred, Armenians have been subjected to systematic discrimination mass killings, torture, and other abuse. End of quote. The court notes that Armenia seeks to found the court's jurisdiction on Article 36, Paragraph 1 of the Statute of the Court in conjunction with Article 22 of CERT. Azerbaijan raises two preliminary objections to the jurisdiction of the court. First, it argues that the court lacks jurisdiction under Article 22 of CERT because the precondition of negotiation has not been satisfied. Second, Azerbaijan contends that some of Armenia's claims are not within the court's jurisdiction, rationi materiae, under Article 22 of CERT. The court starts by considering the first preliminary objection concerning whether the precondition of negotiation under Article 22 of CERT has been satisfied. As the court has observed in a previous case, in order to meet the precondition of negotiation in the compromissory clause of a treaty, the subject matter of the negotiations must relate to the subject matter of the dispute, which in turn must concern the substantive obligations contained in the treaty in question. Further, the negotiations are attempted or have commenced. The precondition of negotiations is satisfied only when negotiations have failed or when they have become futile or deadlocked. Whether negotiations have taken place or whether they have failed or become futile or deadlocked depends on the facts and circumstances of each particular case. The court notes that the parties began exchanging written correspondence related to the present disputes under CERT in November 2020. Armenia initiated correspondence with Azerbaijan by a letter dated November 11, 2020, in which Armenia alleged ongoing violations of multiple provisions of CERT. In its response, dated December 8, 2020, Azerbaijan, and I quote, rejected Armenia's allegations as set forth in its November 11 letter. End of quote. Azerbaijan also stated that it, and I quote, remained open to negotiating this matter. End of quote. Armenia reiterated its claims under CERT in a letter to Azerbaijan dated December 22, 2020, and Azerbaijan maintained its rejection of Armenia's allegations in its response dated January 15, 2021. In the court's view, these specific references to CERT show that the subject matter of these exchanges related to the subject matter of that convention. The court observed that over the subsequent months, the parties engaged in multiple written exchanges and 2 rounds of virtual meetings concerning the modalities, scope and timing of negotiations regarding the substance of alleged violations of CERT. In the court's opinion, all these exchanges formed part of the negotiations between the parties related to a possible settlement of the present dispute. Negotiations dedicated to the substance of alleged violations of CERT began with the face-to-face meeting on 15 and 16 July 2021, during which Armenia presented its claims and requested remedies. The parties held 2 rounds of in-person meetings to negotiate claims and remedies. The first on 15 and 16 and 27 and 28 July 2021, and the second on 30 and 31st of August and 14th and 15th of September 2021. The court observed that the parties' respective positions remained substantially unchanged from Azerbaijan's initial rejection of Armenia's claims in December 2020 until it renewed rejection of those claims at the parties' second substantive meeting in September 2021. The court further noted that Azerbaijan presented specific proposals to Armenia at the 30 and 31 of August 2021 meeting and communicating them again by letter to Armenia dated October 9, 2021. These proposals were for certain joint action that Azerbaijan and Armenia might take, rather than proposals capable of resolving the present dispute under CERD. Against this background, the Court is not persuaded by Azerbaijan's argument that such proposals provide a basis for concluding that the negotiations had only just begun and that further negotiations could still have led to a settlement. The Court is of the opinion that Armenia made a genuine attempt to engage in discussions with Azerbaijan with a view to resolving the dispute as required by Article 22 of CERD. Further, the Court is of the view that these negotiations had become futile by the date on which Armenia filed its application. The Court recalled that evidence of a genuine attempt to negotiate or of the conduct of negotiations does not require that the parties to a dispute have in fact reached an agreement. In past cases, the Court has found that a precondition of negotiation was satisfied when the parties' basic positions had not subsequently evolved after several exchanges of diplomatic correspondence or meetings. Moreover, the Court has held that the actual number or duration of exchanges is not dispositive in this regard. In the present case, the parties' respective positions remained substantially unaltered between the end of 2020 and September 2021. In light of these circumstances, the Court considers that negotiations had become futile because there was no realistic possibility at that stage of a bilateral negotiated settlement of disagreement between the parties. For these reasons, the Court concludes that the precondition of negotiation under Article 22 of CERD is satisfied in the circumstances of the present case. As a result, the Court concludes that the first preliminary objection raised by Azerbaijan must be rejected. The Court then examines Azerbaijan's second preliminary objection, which concerns the Court's jurisdiction ratio in materie. The Court recalls that in accordance with Article 22 of CERD, its jurisdiction ratio in materie covers, and I quote, any dispute between two or more states parties with respect to the interpretation or application of this convention. End of quote. Recalling its jurisprudence, the Court observed that when it is seized on the basis of a treaty's compromissory clause by a state invoking the international responsibility of another state party for the breach of obligations under the treaty, it must be ascertained whether the actions or omissions of the respondent complained of by the applicant fall within the scope of the treaty allegedly violated. In other words, whether the facts at issue, if established, are capable of constituting violations of obligations under the treaty. In determining whether it has jurisdiction, ratione materie, the Court recalls that it does not need to satisfy itself that the acts of which Armenia complains actually constitute racial discrimination within the meaning of Article 1, Paragraph 1 of CERD. Such a determination concerns issues of fact, largely depending on evidence regarding the purpose or effect of the measures alleged by Armenia, and is thus properly a matter for the merits, should the case proceed to that stage. At this stage, the Court must ascertain merely whether the alleged acts of murder, torture, inhuman treatment, arbitrary detention, and enforced disappearance, if established, are capable of constituting violations of CERD, and thus fall within the scope of the Convention. Accordingly, in order for claims to come within the Court's jurisdiction ratione materie under CERD, the applicant must allege acts that, if established, are capable of amounting to a differentiation of treatment based on one of the prohibited grounds under Article 1, Paragraph 1, with the purpose or effect of nullifying or impairing the enjoyment of rights on an equal footing by members of the protected group. The Court recalled that, pursuant to Article 1, Paragraph 2 of CERD, distinctions based on citizenship or current nationality, as opposed to national or ethnic origin, do not fall within the scope of the Convention. However, in the present case, the parties concur that Armenian national or ethnic origin constitutes a prohibited ground for discrimination under the Convention, and the Court agrees with this characterization. The Court then turned to the applicability of CERD in situations of armed conflict. Its common ground between the parties that CERD applies in situations of armed conflict, and that the applicability of international humanitarian law to conduct in an armed conflict does not preclude the applicability of CERD. In particular, both parties acknowledge that conduct may be incompatible with international humanitarian law can simultaneously implicate obligations under CERD, provided that such conduct conforms to the requirements for establishing a claim under that convention. The Court notes that the prohibition of racial discrimination as an essential part of international human rights law is also a fundamental element of international humanitarian law. The Court has previously acknowledged that allegedly discriminatory acts taking place in the context of armed conflict appear to be capable of contravening rights provided by CERD, even if certain of these alleged acts might also be covered by other rules of international law, including humanitarian law. The Court recalled that the protection offered by human rights conventions does not cease in case of armed conflict. The Court further observed that the object and purpose of CERD is to eliminate racial discrimination in all its forms and manifestations. The Convention contains no general restrictions relating to its applicability in situations of armed conflict, nor does it provide for derogation in such circumstances. Indeed, some of the most extreme forms of racial discrimination occur in the context of armed conflict. Accordingly, the Court concludes that the protection against racial discrimination provided by CERD continues to apply in armed conflict. In that sense, CERD and international humanitarian law are complementary. The Court emphasizes, however, that its jurisdiction in the present case is limited by Article 22 of CERD to Armenia's claims under that convention. For these reasons, in the Court's view, acts of murder, torture, inhuman treatment, arbitrary detention, and enforced disappearance allegedly carried out on the basis of the national or ethnic origin of the victim are capable of constituting violations of obligations under CERD, including in an armed conflict. In light of this, the Court must ascertain whether the specific acts complained of by Armenia are capable of establishing discriminatory treatment based on the victim's Armenian national or ethnic origin. The Court then considered the arguments put forward by Azerbaijan against Armenia's claims that Azerbaijan has subjected ethnic Armenians to acts of murder, torture, and inhuman treatment on the basis of their Armenian national or ethnic origin in violation of Article 2, Paragraph 1, as well as Articles 4a and 5b of CERD. The Court recalls that, unlike international humanitarian law, CERD does not distinguish between members of armed forces and civilians. In light of this, the Court considers that Armenia's claims concerning the discriminatory treatment on the basis of national or ethnic origin of both members of armed forces and civilians fall within the scope of CERD. The Court is of the view that the acts alleged by Armenia are capable of constituting discrimination against members of armed forces and civilians based on their Armenian national or ethnic origin carried out with the purpose or effect of interfering with rights protected under Article 2(1), 4a, and 5b of CERD. This includes the treatment of ethnic Armenians who reside in Nagorno-Karabakh. The court observed that the consequence of Azerbaijan's submissions would be the exclusion of a claim from the court's jurisdiction Rashwani materia under CERD if some alternative explanation or interpretation of the harm alleged by Armenia is available. At the jurisdictional stage, however, the court need only determine whether the acts alleged are capable of constituting violations of CERD, and thus fall within the scope of the Convention. The court observed that racial discrimination can be a highly contextual phenomenon, and identifying racial discrimination may require careful assessment of the facts and their implications. Whether the material submitted by Armenia in support of its claims is sufficient to demonstrate that the alleged acts of discrimination in question were in fact based on the national or ethnic origin of the victims is a matter for the merits and cannot be determined at this stage of the proceedings. With respect to Armenia's claimed evidence regarding generalized anti-Armenian animus, the court has previously acknowledged in its order of December 7, 2021, indicating provisional measures that rhetoric, I quote, promoting racial hatred and incitement to racial discrimination can generate a pervasive racially charged environment, particularly when employed by high-ranking officials of the state, end of quote, and increase the risk of bodily harm to members of the protected group. The court notes that Azerbaijan has not objected to the court's jurisdiction in respect of Armenia's claims relating to its alleged glorification of racially motivated violence or hate speech against ethnic Armenians. The court considers that the alleged pervasive atmosphere of racially discriminatory speech and sentiment is relevant to its assessment of Armenia's assertion that certain acts complained of are capable of violating obligations under CERD. The extent to which such generalized anti-Armenian sentiment, if proven, can be invoked to demonstrate that specific acts were based on prohibited grounds under Article 1, Paragraph 1 of CERD, is not a question that the court needs to determine at this stage of the proceedings. Accordingly, the court concludes that Armenia's claims of alleged racially motivated murder, torture, and inhuman treatment of ethnic Armenians fall within the scope of Article 2, Paragraph 1, Article 4a, and Article 4b of CERD. The court then turned its attention to the claims concerning arbitrary detention and enforced disappearance. Taking into account the reasons set forth in its analysis of the arguments advanced in relation to murder, torture, and inhuman treatment, the court is of the view that the acts alleged by Armenia in relation to arbitrary detention and enforced disappearance of ethnic Armenian civilians are capable of constituting discriminatory treatment based on Armenian national or ethnic origin carried out with the purpose or effect of interfering with rights protected under Article 2 and Article 5a of CERD. This includes the treatment of ethnic Armenians who reside in Nagorno-Karabakh. Accordingly, the court concludes that Armenia's claims regarding the alleged racially motivated arbitrary detention and enforced disappearance of ethnic Armenians fall within the scope of Article 2 and Article 5a of CERD. Thus, the Court finds that the claims advanced by Armenia in Part 6, Chapter 3, Sections 1, 3, and 4 of its memorial fall within the scope of CERD. Accordingly, the Court concludes that Azerbaijan's second preliminary objection to the Court's jurisdiction must be rejected. I shall now read out the operative part of the judgment. For these reasons, the Court, by 16 votes to 1, rejects the preliminary objection raised by the Republic of Azerbaijan. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi, Judge Adok Dode. Against, Judge Adok Koroma. 2. By 15 votes to 2, rejects the second preliminary objection raised by the Republic of Azerbaijan. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tlati, Judge Adok Dode. Against, Judge Yusuf, Judge Adok Koroma. 3. By 15 votes to 2, find that it has jurisdiction on the basis of Article 22 of the International Convention on the Elimination of All Forms of Racial Discrimination to entertain the application filed by the Republic of Armenia on September 16, 2021. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi, Judge Adok Dode. Against, Judge Yusuf and Judge Adok Koroma. I now call upon the Registrar to read the operative part of the judgment in French.
Par ces motifs, la Cour, 1, par 16 voix contre 1, rejette la première exception préliminaire soulevée par la République d'Azerbaïdjan. Pour M. Salam, Président, Mme Sebutinde, Vice-présidente, M. Tomka Abraham Youssouf, Mme Choué, M. Bandari Iwasawa Nolte, Mme Charlesworth, M. Brand Gomez Robledo, Mme Cleveland, M. Orescu Tladi, juge, M. Daudet, juge ad hoc, contre M. Koroma, juge ad hoc. 2. Par 15 voix contre 2, rejette la seconde exception préliminaire soulevée par la République d'Azerbaïdjan. Pour M. Salam, Président, Mme Sebutinde, Vice-présidente, M. Tomka Abraham, Mme Choué, M. Bandari Iwasawa Nolte, Mme Charlesworth, M. Brand Gomez Robledo, Mme Cleveland, M. Orescu Tladi, juge, M. Daudet, juge ad hoc, contre M. Youssouf, juge, M. Koroma, juge ad hoc. 3. Par 15 voix contre 2, dit qu'elle a compétence sur la base de l'article 22 de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale pour connaître de la requête déposée par la République d'Arménie le 16 septembre 2021. Pour M. Salam, Président, Mme Sebutinde, Vice-présidente, M. Tomka Abraham, Mme Choué, M. Bandari Iwasawa Nolte, Mme Charlesworth, M. Brand Gomez Robledo, Mme Cleveland, M. Orescu Tladi, juge, M. Daudet, juge ad hoc, contre M. Youssouf, juge, M. Koroma, juge ad hoc.
Judge Yusuf appends a dissenting opinion to the judgment of the court. Judge Iwasawa appends a separate opinion to the judgment of the court. Judge Adok Koroma appends a dissenting opinion to the judgment of the court. The text of the judgment is available from today in typescript. It will also be available shortly on the court's website. The printed text will be available in the near future. This brings to a conclusion the sitting in relation to the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. After a short break of 10 minutes, a new sitting will begin for the purposes of reading of the court judgment on the preliminary objections in the case concerning application of the International Convention on the elimination of all forms of racial discrimination, Azerbaijan versus Armenia. The sitting is closed.